All right, you've been watching opening statements in the case against Brian Walshe and his murder trial from the courthouse there in Dedham. Both prosecution and defense having their opening statements. The judge granting the jury a time to take a quick little break. And we'll kind of discuss what we're seeing here with retired District Court Judge Jim Barretto, who's joining us here at the anchor desk. Jim, what do you think from what you just heard moments ago with the defense and the prosecution?
Sure. Doug and Erica, thank you for inviting me. The openings were well delivered by experienced counsel who are experienced in serious criminal cases, criminal prosecution, including, of course, murder. The Commonwealth laid out a meticulous case and did their best to humanize Anna Walshe. And so the jury, despite her absence, might be able to see her to the best that they could achieve. They discussed her disappearance in great detail. They discussed Brian Walshe's behavior after she disappeared. They discussed the discovery of trash bags with very concerning items contained in them. They also discussed briefly, but nonetheless did, various tools that were discovered inside the bags that could play a major role in Anna's demise, or could have played a major role. They also discussed digital evidence, which you wouldn't have seen 30, 40 years ago, which tells you why this case might be possible today. That digital evidence, which is ghoulish, involves how to stop a body from decomposing. Forgive me for this, I don't want to misquote.
Yeah, these are Google searches that were connected to Brian Walshe's devices. Exactly,
Eric, and I don't want to misquote them. 10 ways to dispose of a body if you really need to. Can you throw away body parts? Can identification be made on partial remains? How to clean blood from a wooden floor? Hacksaw, best tool to dismember. Can you be charged with murder without a body? So all of the digital evidence was touched upon, and we're going to hear much more about that.
Yeah, I think the prosecution, we expect something like this, laying out the story, giving the details. Yeah. I think what was wild about this morning was really the defense opening statement. I mean, just from the top, this is Larry Tipton, who's representing Brian Walshe, saying Brian Walshe lied to police. They admitted to purchasing those tools, a hacksaw, some of the grisly details, admitted to the Google searches, admitted that Anna Walshe died, and then gave a reason.
Yeah.
Which was no reason at all. Unexpected death.
Yeah, I mean, we finally saw the pivot that many of us had anticipated. I'm not sure we anticipated this exact pivot, an unexplained sudden death. But they conceded the death, so some of us were wondering about that. That was conceded at the outset. They talked about the fact that he went down in the kitchen, came back up, and she just died. Frankly,
it's the behavior after the death that will stick out in people's minds. The explanation, is this an explanation that a jury will buy?
Where's the call to 911 when he finds her that she's not breathing in bed?
Frankly, it stretches credulity. I mean, there's no other way to put it politely. It stretches credulity.
Also, something that we know that the jury was not presented today is that Brian Walshe already pleaded guilty to 2 counts, misleading police, moving Anna Walshe's body. He admitted then that she had died. The jury did not hear that.
Yeah, I found myself in a minority position on that. First, he hasn't been convicted of that. The actual changes of plea don't mature into a conviction until he's sentenced. And as you know, Judge Frenier put sentencing off until after this trial. So the convictions aren't going to come in. The question in my mind is and remains, are the admissions that he made during the very thorough colloquy that Judge Frenier administered, can they come in as classic exceptions to the hearsay rule? Admissions are a classic exception.
And the thing here is there has to open the door to reasonable doubt. And that was the instructions to the jury. Is the defense going down the right path? Do they have the right key to open the door here with this idea that he went up into bed after cleaning the kitchen and reading some emails and she was dead?
It was always a reasonable doubt case. All these no-body cases are reasonable doubt case, but frankly, I suspect or sense that the reasonable doubt argument now is actually more difficult.
Which is a point because there's no body that's been found,
Right.
so we don't have a clinical explanation of how she died.
Right, and we never did.
No.
Which is why the Commonwealth has put so much extraordinary effort into building an elaborate circumstantial case. And this will, in the end, come down to circumstantial evidence. But what the defense has done now, in addition to realizing, of course, it has always been a reasonable doubt, it's always been a consciousness of innocence case, they now have introduced credibility. What to believe, who to believe. Are you going to believe that after coming upstairs and finding your wife suddenly dead, that you don't call 911, instead you hatch a plan and
to protect the kids. To protect the kids.
To protect the kids and dismember a body.
Something else to keep in mind, if they are leaning on Brian Walshe and how credible of a witness he may be. You said when you were listening to the defense, it sounds like Walshe may take the stand, and later on in the opening, Larry Tipton did say, as Brian Walshe will tell you. So do you think he will in fact take the stand? And is he credible knowing that he had been convicted of fraud before, which the jury will know, and that his own attorney is saying he lied to police?
I would have bet money he would not take the stand. And I realize there are others out there who are saying, well, maybe what they did with the change of pleas triggers a signal that he's going to take the stand. But he's extraordinarily vulnerable if he were to take the stand. As Erica pointed out, the federal conviction will be admissible to impeach his credibility, and not to mention all the lies he told the Cohasset police in the days starting literally on the first day, January 1, January 2, January 3, January 4. How is he going to get out of that? All of that is fertile ground for cross-examination by Mr. Connor, the chief prosecutor in the Norfolk County District Attorney's Office. So if he does take the stand, and you're right, Erica, there was a clear hint that he might. I don't know where that goes.
One last question. This is really kind of outside the jury box in the sense of optics. The jury did not see Brian Walshe come in shackled, handcuffed prior.
And as they shouldn't.
Right. But what they can see, and I know if we saw it on camera, he's holding what appears to be rosary beads. Is that something that is normal in court for a defendant to be able to show some type of religious artifact?
Well,
that was just something that I happened to catch, that the jury might see.
It's a good question. I've been on, or was on, excuse me, I'm a retired judge since last July, but I was on the bench for over 15 and a half years, hundreds and hundreds and hundreds and hundreds of cases. I've never seen that once. As a matter of fact, in the, if you go back a little bit, when there was the controversy in the Catholic Church, priests were made to take off the collar. They don't like people with obvious religious affiliation sitting there. I'm glad you noticed it. I don't know if Judge Frenier might have a comment about it. We'll see, but that's unusual.
Well, certainly, we will be watching this case closely. The jury taking a break now, and of course, we're going to report the very latest on News Center 5 at noon. But really, Jim Barretto, a former district court judge, thank you for your insight today.
Thank you for having me.
Ever seen anything like this?
No. I'm not sure we will in a while.
No, thank goodness. All right.